Right.
Okay, makes sense. Okay, and so this gives, because I think the trust, because it has a little bit more flexibility and you could do a little bit more inside of a trust, let's kind of talk a little bit more about the trust. And a question came up about the difference between a revocable trust and a irrevocable trust. So let's just kind of clear up the air and explain what those two are.
Okay.
Under the trust.
Yeah, a very common question. And again, you can look it up online, and usually they answer it correctly. But revocable means you can change it anytime during your life, so long as you have the mental capacity to do so. So most of the trusts that I do are revocable living trusts. So a living trust meaning it was made during your life. So that's what those terms mean. An irrevocable trust means once you create it and once you sign it, it cannot be changed. But we usually don't do those unless the only time I do them in my practice is if I'm doing Medicaid planning for someone who's later in life. Because if it's an irrevocable trust, it takes the assets out of their name legally, and then they can start that 5-year look-back period for Medicaid planning in the future. Also, sometimes it's done for more advanced asset protection planning, but otherwise irrevocable would be done for Medicaid planning. All other trusts would be revocable living trusts.
Okay. So, and that would definitely be one area that you definitely need to sit down with an attorney to go through. So for a trust, is a trust something that the attorney actually has to set up, or can people do it on their own?
Well, again, people can do it on their own, but it is, do you know what it is that you're doing? I mean, it is paperwork. Right. It is paperwork that's being signed. So do you know what it is that's included in there? So it's the same analysis as if you're using an online document. Of course, anyone can do it, but is it wise to do it that way?
Okay. And then now, and just a quick side note, when we're because you mentioned this earlier, and now I see the question. Does it change from state to state? How do they recognize the next of kin? So if a person hasn't completed their estate planning, what is the order for next of kin?
It kind of depends on what we're talking about. If you're talking like the assets and what would happen for the money, if you're married and without children, then it would go to your spouse. If you are married with children, and it doesn't matter if they're minors or adults, if you're married with children, half of your estate will go to your spouse and the other half goes to your children. The spouse may have to do accounting to the courts if they're minors for how they care for that children's half the money. They may have to put up a bond. They definitely have to do the accounting. So another reason to do your estate planning ahead of time. It does also depend on how the assets are titled. So if you have like a property, like you own your home with your spouse, usually depending on how it's titled, it would automatically go to them, so that wouldn't be split. So it does depend kind of how you have some of your assets set up. If you're not married, then your children are going to equally inherit. If you're married without children, the spouse, as we said, gets it. If you have no spouse or children, then your parents will inherit. And then if you have no parents, then it goes to the siblings. So it goes to spouse, children, parents, and then siblings. If you're talking about who's going to next of kin for like health care or guardianship decisions, that's, you go through the courts, guardianship courts, and then the court looks at all different circumstances to determine that. That's not just set up in the state laws.
Oh, okay. Okay, that's good to know. Okay. So I think we kind of have a really good understanding of the estate plan, the components of the estate plan, some good general information about each component as far as the power of attorney, the will, and the trust. And so now, because I did reach out to some of my clients and some moms that had questions, and so these may be a little detailed, and if they need to speak with attorney more in depth, just let us know. Or if you can just give us some little general information that can kind of help guide them on these circumstances. But I had a parent that asked, if a parent died before a 529 college plan is used, does it get passed on to the estate or directly to the child beneficiary?
Well, that is one thing that you can work with whoever is providing the 529 plan. The account is going to pass to a new account owner. So if obviously usually they're set up for minor children, then it is going to go to someone else. So you can set it up with the accounts who the successor owner is going to be. If you don't name anyone, then it's going to have its asset that is going to go into probate court, and they're going to figure that out. So just like if you have life insurance and you set up, who the beneficiaries are going to be, with the 529 plan, you can also set up who the successor owner is going to be. So, it could be your spouse, it could be someone else that you would trust with that. But do keep in mind that whoever the successor owner is going to be will have all the rights that you have to it, including being able to cash it out. So, and this is a good point for anything that you do. Whoever you elect as guardian of your children, the executor of your will, the trustee of your trust, it has to be someone you trust and who knows you and who has an idea how you would want things done, because they are basically stepping into your shoes to fulfill your wishes. So it has to be someone that you do trust in order to do this, because they're going to have a lot of rights to this and to the money that you have in your estate. So make sure it is someone you trust who is going to do that for you.
Okay, great. And I guess that's why it's so good to really detail out in the trust how you want things to go. And a question about the trust, who makes sure, because when you have a trust, you have to sign an executor over the trust or the estate. And that person is the person that makes sure that your wishes are followed out, correct?
Yes, for a will, it's called the executor, and for the trust, it is the trustee, right?
Oh, okay. The will is see, I just learned something. So when you have a will, it's called the executor, and when it's the trust, it's the trustee. Okay. So let's talk about the trustee. If I sign a trustee, because we know that, and I share this with my moms when they go through the program, you never know what state of mind a loved one is in if something happens to you, because as a mom, you are so valuable. And, when people lose a mother, you just don't know how their mental capacity could change. And so although right now, this person would ideally do whatever you want, would make sure everything is taken care of, you just don't know how your loss would actually affect them. And that's your children, your spouse, your parents, your sisters, your brothers. You just don't know. And so you have assigned a trustee over your trust to, make sure everything is handled. Who watches over the trustee, or once that trustee is assigned, then they just have the responsibility of seeing everything through? Or is there anyone to watch over the trustee to make sure that the trustee is doing what they're supposed to do?
Well, the beneficiaries are the first and foremost the ones that have the rights, because it's their money that the executor or the trustee would be handling. So if they're not happy with how things are being handled, they can ask and request the executor or trustee to step down. Sorry, when you have, whenever I do the documents, we always list at least 2, preferably 3 or 4, total executors or trustee, each in succession, each in line after the other. So if they're not happy with it, or if the finance is not being handled properly, they can always request the executor to step down, and then the next one in line would take over. If they refuse to step down, they do have to provide accounting to the beneficiaries. It can be requested at any time. Whoever the guardian is for the children would also be able to ask for all of the accountings and to be able to watch what's going on. They do have a duty to act in good faith, so it is a fiduciary duty which is legally enforceable. So if they're doing things that are incorrect, they would be personally liable. If they're doing things that are, either illegal or just making really bad decisions. Of course, if, executors or trustees, if they're making honest mistakes or honestly, the finances just aren't working out, they won't be held liable. But if something, not good is going on, then they could be held liable for that. So the beneficiaries. And, if worse comes to worse, they could always go to court to try to enforce that. If the executor refuses to step down or if something is not going right, then you would wind up in court for that. That's not the same as contesting a will. It's only contesting, the removal of the executor and how they're handling it. So it would not be as costly as going through the entire probate process unless there really is a huge court battle which goes on, but that's unlikely and not very common.
Oh, okay. 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 And here's something that's kind of common. What happens if you set up everything and you are not, as a mom, you may not be legally divorced, but you and your spouse have not lived together in, let's say, over 5 years? Can the spouse come and contest your estate plan?
Well, I would rather... I would say if this is you and this is happening to you, you need to discuss it with a divorce attorney as well, because this does also overlap with divorce law. But for estate law, yes, they would be able to. It's my understanding that if you're still legally married, they do have a right to a legal share of the estate. If you're not divorced legally, there are things you can do. You can go and make sure they're no longer beneficiary on any of your accounts. Especially life insurance. You can have life insurance that doesn't go to your spouse. So these are things you need to make sure of. But I would highly recommend go ahead and get that divorce, because they do have a legal rights. There is this spousal election in Illinois. I haven't dealt with that because that's more of an estate administration and after-death issue. But they do have a right to a share of the estate. So, yeah, you have to get that. And if this is you, go and get the divorce, get it started.
Yes. Because, people they just kind of fall apart and they go their separate ways and they never even think about it, and you just don't know what can happen, and then you realize you're not divorced. And believe it or not, there's a lot of people that are living apart and just have not legalized their separation and just haven't even thought about it. But at some point, it can probably come back to bite you.
Oh, absolutely. Yeah, absolutely. And especially if you have children, that you want to make sure that it goes to your children and not to the spouse that you're no longer with, then yeah, definitely go ahead and file the paperwork and get it going. It affects many areas of your life, not just estate planning.
Yeah, okay. And then another question came up. If my child's father gave me sole custody, and that's through the court, and he doesn't have a relationship with the child, in my will, can I allow someone that she has a relationship with, the child, to care for her? And how successful will he be if he decides to come and contest it, even though he's given that person, the mother, sole custody to make decisions?
Right, and this does come up a lot. We try to draft around it as much as we can, but the courts will always look to the biological father as a potential, new custodian for the child. That's just the way it is. Even if the mother has sole custody and the father lost her rights, they will still look at the father. There are ways that you can help make sure that he will not get custody. If there is any incompetency issues, certainly those products can be released, document shows that for your family members. You can't look at certain guardians why.
Hello? Hello? Okay, so we had a little interference, and I don't know what happened, but just want to just go back over the last question because that's when things started getting funny. But the question was, if my child's father gave me sole custody through the court and he didn't have a relationship with the child, in my will, can I allow someone that she has a relationship to care for her, because in this case she would still be a minor, and will he be successful at contesting the will?
Well, this is something that you can try to work your way around. The courts will look to a biological father as a potential custodian for the child, even if in your will you list other people as guardians. You can list your reasons, like if the father is incompetent or such like that. You can list that in the will as to why you're choosing other people to be a guardian. But if the biological father wants to contest that, they can, and that will be up to the judge. Of course, your family will be able to present evidence that they are unfit or why you received full custody in the first place. So if there's something going on there that wouldn't be a good fit for your child to be with the biological father, then the court will look at that and make a reasonable decision. So you can say who you prefer and why in your will. You just have to be careful not to say anything slanderous. Just list the facts about why you think the biological father is not suited to be a custodian for the child, such as that they don't have a relationship with them and maybe they're unfit. But if you are worried that the biological father is only going to be interested in becoming a custodian over the child because they think perhaps that they're going to have access to the child's money, that is definitely something that you can take care of, and especially with a trust. If you put the trust and you name other trustees who are going to have access and control over the child's money, then the biological father, even if they get custody, would not have access to that child's money. And that would be up to the trustee as to when and how much to pay out until the child, inherits the bulk of it when they're adults. So those are things that definitely should have your estate plan in place if this is your situation, and these are things that you can work around. But you can't just leave the biological father out completely, not legally. But there are ways that you can do to kind of plan and work around that and try to get the best for your child if that does happen.
Okay, and something I just thought of something, and I'm not sure if this would, if you can answer this because it speaks about Social Security. Because if a parent passes away and they've worked, that child is eligible for Social Security. Do you know who does the Social Security, can that go into the trust for the executive to distribute, or does it have to go to the person who is physically responsible for caring for the child? Do you know anything about that, or is that another area?
Unfortunately, I haven't dealt with that, so I would have to do research on that. I actually don't know. That's something I would have to look up.
Okay.
But, if a client came to be with that situation, I would definitely research it and find it out.
Yeah, because that just kind of popped in my head because I actually have a mom that passed away, and it's a whole mess. And which is one of the reasons why I really started my program, Mom's Master Plan. That she was one of the reasons. She was a good friend of mine, and she passed away. And that is really, she didn't have an estate plan, and her sister, who ideally will be the one to take care of her daughter, she did have her daughter, but the father stepped in, and when I say it became a complete mess, she wound up turning that Social Security check over. She doesn't even know who gets the Social Security check, and the person that gets the check is not the one that's taking care of the kids. So it's a whole mess behind that, which is one of the reasons why I'm so passionate about this topic and making sure that moms understand this process and how it works and how it can eventually affect their family and just totally delete their voice after so many years of taking care of their family. So that just kind of popped in my head when you were talking about that. So definitely something for me to research as well. So it looks like